and welcome to Magna Carta and its American legacy. My name is Jonathan Barth, and I am Assistant Professor of History here at ASU, and it is my pleasure to moderate the event this evening. Now, before we get started, I would like to recognize three sponsors of this event who devoted an exceptional amount of time and energy into organizing this event and making it possible. First, we have the Arizona Center for Medieval and Renaissance Studies. And in particular, we have Kendra Terbeek, we have Robert Bjork, and Sharon Pedrick. We also have the Sandra O'Connor College of Law, and in particular, James Weinstein. And lastly, we have the Center for Political Thought and Leadership, the latter of which yours truly proudly belongs to, as well as Professor Donald Critchlow and Roxanne Barwick. Each of these sponsors put considerable time and energy into making this event possible, and I do encourage each of you to, after the event, go out to the tables outside there and check out some of the information on these two centers and the College of Law. And if you are a student here for extra credit, also be sure to sign, to fill out one of the forms, the assessment forms, just so we have some barometer to measure how successful this event was, and so you can receive credit if this is something that your professor offered. Make sure to put your name on it and the course number, as well as the professor. My own period of expertise is early modern English and American history. And I have to say that especially concerning the 18th century, but also in the 17th century, one of the themes that I recurrently encounter is this notion of the English Constitution. The English Constitution. And as most of you know, the English Constitution is not a single document, but rather it is a collection of documents that evolved over many centuries. And there are three documents in particular that play a central role in the English Constitution. One of those documents is the Petition of Right from 1628, when Parliament, in protest against the arbitrary rule of King Charles I, issued a petition outlining certain prohibitions on the king's behavior, including non-parliamentary taxation, prohibiting imprisonment without cause, and prohibiting the use of martial law. The petition wasn't all that successful. Charles I dissolved Parliament the following year and ruled without a Parliament for 11 years. And then England plunged into a long civil war. However, to this day, the Petition of Right, 1628, is recognized as one of the cornerstones of the English Constitution. Then we also have the Bill of Rights. The Bill of Rights, which Parliament passed in 1689, shortly after deposing King James II. And in the Bill of Rights, we have a limitation on the power of the monarchy. And we also have an enumeration of certain liberties, including frequent parliaments, freedom of speech in Parliament, a prohibition on cruel and unusual punishment, and the right to bear arms. But if we had to identify a single document as the bedrock of the English Constitution, no doubt that document is Magna Carta. Magna Carta. Carta, Latin, of course, for the Great Charter. The Great Charter. 800 years ago, in the year 1215, a group of nobles, rebel barons, compelled King John to agree upon a set of limitations on his supposed regal prerogative. And in discussion of this document this evening, we do have three distinguished, highly distinguished speakers. Our keynote speaker tonight is Henry C. Clark, and he will begin with a talk entitled The Importance of Magna Carta for Today. Andrew Chodorow will follow up with a talk entitled Magna Carta, a Tax Professor's Perspective. And Myles Lynk will conclude with a talk entitled Restraints on Executive Authority, Magna Carta, and the U.S. Constitution. And then, after the three speakers are finished, we will have a question and answer in which you, the audience, may begin a dialogue with the speakers tonight. But first, to begin this event, we have Henry C. Clark. Dr. Clark has been a visiting professor in the Political Economy Project at Dartmouth College since 2014. Before then, he taught at Canisius College and Norwich, Lawrence, Tulane, and Clemson universities. He is the author or editor of 5 books, mostly in the fields of early modern French history and intellectual history. His articles and reviews have appeared in journals of history, political science, philosophy, and economics. And he is currently working on sumptuary law as a way of thinking about the rise of capitalism. So please join me in welcoming Henry C. Clark.
Thank you, John, and thank you all for being here. When Marge Simpson took her viewers on her Margical History Tour, that's episode 324 for those of you keeping score, her lesson, which included a gluttonous Henry VIII wiping his grubby mouth with Magna Carta as a napkin, presupposed that her audience knew and cared what Magna Carta was. In a general sense, this strikes me as a bit odd. For if there's anything that we know about the Middle Ages, it's that it is the perfect poster child for everything that the modern world, and especially America, is against. We don't agree about much anymore in this country, but one thing I thought we did agree on is that the age of the Crusades, the Inquisition, and trial by ordeal hold nothing worth remembering. The 800th anniversary of that meeting in Runnymede in June has been a jolt to that mean. If we ask ourselves why we make an exception for Magna Carta, another oddity awaits us. It can't be simply because of the intrinsic importance of the subject. We owe plenty of important things to the Middle Ages that we rarely stop to acknowledge. Everything from papal checks on empire, to chivalry as a curb on misogyny, to the university itself, which after all is a medieval invention. Nor can it be the continuing relevance of the text itself. Only 3 clauses out of the 64 from the original charter still remain on the statute books, and they include obscure provisions on the City of London and the Church of England. So if Magna Carta means anything to us today, it must be mostly because it has become a symbol. And the big question that occurred to me as I was preparing this talk is how far it has somehow become part of what Lincoln might have called the mystic chords of our memory. One way of gauging its importance might be to distinguish between three different types of symbolism that it has represented. I propose to call them the commemorative, the associative, and the critical. The commemorative is obvious enough, and it's not necessarily mere formalism. There can be a cumulative effect in commemorations that make it greater than the sum of its parts. For example, on the 750th anniversary, on June the 15th, 1965, Secretary of State Dean Rusk traveled to Runnymede to receive an acre of its land from the Queen in memory of John F. Kennedy, who had died 2 years before. The JFK Memorial, along with one established by the American Bar Association 8 years before that, reminds visitors even today of the unique relationship between the United States and Great Britain. This commemorative use can also be a way of showing gratitude for specific assistance, and has often done so. In 2010, to take one recent example, a Florida congressman began a resolution recognizing the close friendship and historical ties between the U.S. and the U.K. with an evocation of Magna Carta. The occasion? It was his way of thanking the British for supporting the United States in the recent Iraqi war, when many European countries had balked at doing so. Secondly, what I call the associative refers to times when Magna Carta is evoked as a way of spurring people to collective action because of the general bond that they are assumed to share. Perhaps the most famous example of this occurred in 1939, just before the war. At the New York World's Fair, the British government had mounted a Hall of Democracy exhibit where they had placed a copy of Magna Carta on display side by side with a genealogy of George Washington, placed there for the sesquicentennial of the American founding. This harmless exercise in commemorative symbolism quickly morphed into a more active associative project when the war broke out a few months later. At first, the parchment document was stranded on our side of the Atlantic, but that led some enterprising British officials to concoct the idea of granting the copy to the American people as a permanent gift, in hopes that the historic ties between the two countries would, in the words of a British government memorandum, greatly heighten the emotional interest of Americans in the war against fascism. The memorandum went on, I quote, "The gift of Magna Carta would represent the only really adequate gesture which it is in our power to make in return for the means to preserve our country." Unquote. In the darkest days of the century, a hard-nosed British official thought that this mere symbol could help England survive. Finally, there's what I've called the critical use, which is divisive as well as associative in that it looks to overcome opposition to some proposed change. In the great global transformation that we have seen in the past century, the critical use of Magna Carta seems to me by far the most interesting. And here is where the paradox of using a medieval document as inspiration for modern memory is most acute. Let me make one more distinction, namely between the civil and the political. I mentioned that Magna Carta is no longer mostly part of the statute books, but the notable exception to that is the famous clauses 39 and 40 on trial procedure, with its language about judgment by one's peers, the law of the land, the prohibition against bribery, and the delay in justice. Although the meaning of these clauses is subject to historians' interpretations, it clearly was not identical to our own, and yet these clauses have for centuries served as symbols of broader continuities in Anglo-American law. Now, the first thing to be said about this critical use of the civil rather than political legacy of Magna Carta is that it has spanned the partisan spectrum. In the summer of 1939, at the very time when Neville Chamberlain's government was displaying a copy of the charter here, that same government passed Defense Regulation 18B, which authorized the arrest and indefinite confinement of anyone thought to be a national security risk. The very next year, Oswald Mosley and other members of the Union of British Fascists were detained under the new regulation. The fascist presses then unleashed a whole raft of outraged pamphlets with titles like Runnymede Reversed and Magna Carta in the Dustbin in protest against the government's policy. The message being that Magna Carta provides civil rights protections for fascists too. Another example is that both sides of the racial divide have for centuries used Magna Carta for their divergent purposes. Groups as disparate as Britain's Jamaican Plantation Owners Assembly in the 1720s on the one hand, and the Mangrove 9 defendants of the British Black Panthers movement in 1971 on the other, have cited a jury of Europeans' language to argue for racially homogeneous juries of different races, of course. In this country, too, Magna Carta has brought together strange bedfellows. In 1955, for example, the two defendants charged with the lynching of Emmett Till in Mississippi, after being found innocent by a jury of their peers, admitted their guilt publicly. An outcry arose, and Congress prepared civil rights legislation to prevent any future repeat. But opponents of the legislation were quick to cite Magna Carta on their side. As Congressman Jamie Whitten of Mississippi told the House committee, quote, "The defendant is not required to testify against himself. It is a principle that has existed in the English law back to Magna Carta days." Closer to our own time, too, the detainees at Guantanamo successfully invoked the Great Charter to complain about their extended confinement without trial. In the Supreme Court's judgment of Boumediene versus the Bush administration, Justice Kennedy offered this view of history. Quote, "Gradually the writ of habeas corpus became the means by which the promise of Magna Carta was fulfilled." So the critical edge of Magna Carta in civil and criminal law continues to attract interest in the Anglo-American world even up to the present day. What about its broader political inspiration as a model for the organization of government itself? Since modern government has changed more than modern law has since the days of the feudal monarchy, we might think that Magna Carta has relatively little inspirational value. But in fact, the story is a little more complicated. It is certainly true that there is nothing comparable in our own time to the passion that surrounded Magna Carta during the great constitutional struggles of the 17th and 18th centuries. In the 17th century, it symbolized the idea that no one, not even the ruler, is above the law, watched over by an independent judiciary, and that the people have a right both to be consulted about their government and to resist any ruler who attempts to raise himself above the law. In the 18th century, Magna Carta came to serve as a broad symbol not only of civil justice, but of political accountability. The maverick journalist and politician John Wilkes made Magna Carta a touchstone of his highly popular campaign for a free press and broader electoral participation. And in France, the Republican theorist Abbé Mably thought Magna Carta had turned the English feudal monarchy into, quote, "a sort of republic," unquote. To be sure, not everyone agreed that Magna Carta was an important source of political liberty. Voltaire, for example, the key figure of the 18th century European Enlightenment, admired English liberty, but traced almost none of it to Magna Carta. His idea was that since the charter was addressed expressly to free men, the implication was that many people in England were not free. True freedom, in Voltaire's view, was almost entirely modern. Alexander Hamilton seems to have broadly agreed. In Federalist 84, he was skeptical of adding a Bill of Rights to the proposed Constitution because a Bill of Rights is like a charter of privileges. These charters had usually been presented as free gifts by royal grace upon the people, rather than as acknowledgments of the pre-existing rights of the people. Hamilton saw Magna Carta as a perfect example of this, being a charter of liberties wrested from King John, sword in hand in 1215 by the barons. Not a fit model for a free people. An argument repeated in our own time by people like Achille Reid Amar, the sterling professor of law at Yale University. But Voltaire, Hamilton, and other skeptics were fighting an uphill battle. The 18th century was generally the high tide of enthusiasm for Magna Carta as a kind of constitutional beginning. It was in this period that consumer goods with Magna Carta insignias flooded the market. Wedgwood teapots, Staffordshire mugs, porcelain jugs, Warren handkerchiefs. I think most of us would be surprised to find such paraphernalia in a Walmart superstore today. When Americans first evoked Magna Carta, it was sometimes in defense of the particular rights of Englishmen, which they claimed that were being denied. What better proof of the legitimacy of their cause than a document that all Englishmen of whatever party revered? But as the Revolution itself was presented to the world in general terms, Magna Carta was eventually enlisted in the more general cause of universal human rights. The 18th century comment that strikes me as most helpful in understanding this later development was made by Edmund Burke, normally seen as founding father of modern conservatism for his blistering critique of the French Revolution. Burke nonetheless set the tone for a certain kind of progressivism based on gradual, non-revolutionary change when he called Magna Carta, quote, our oldest reformation, unquote. It's an interesting choice of words. Of course, he meant it in a relatively cautious sense, as embodying what he called the precedent, authority, and example, unquote, that liberty as an inheritance is based on. But a reformation, after all, is also a reconstitution, a new beginning, something that emphasizes discontinuity as well as continuity. And that is how some of the 16th century Protestant reformers originally used the term. In a way, this forward-looking use of Magna Carta in America began with Teddy Roosevelt. In 1903, at the 300th anniversary of the King James Bible, TR claimed that the Bible is nothing less than, quote, the Magna Carta of the poor and the oppressed, unquote. A line repeated by countless after-dinner speakers and Sunday sermonizers throughout the 20th century, and certainly an interesting formulation for those of us who think of the great medieval treaty as a conspiracy of wealthy barons. But it was really during the New Deal, under his relative Franklin Roosevelt, that Magna Carta became a promiscuous cliche for almost any new law that any forward-looking progressive might want to endorse. Labor leaders saw the National Recovery Act as a new Magna Carta for the workers. The Merchant Marine Act of 1936 was repeatedly hailed as the Magna Carta of the American Merchant Marine. Independent oilmen viewed the federal antitrust acts as their Magna Carta, and so forth and so on throughout the whole decade of the 1930s and beyond. It was out of this New Deal tradition that Eleanor Roosevelt spoke when she said that the Universal Declaration of Human Rights, conceived out of the rubble of war and adopted by the new United Nations in 1948, quote, may well become the international Magna Carta for all men everywhere, unquote. Nor is it only Americans who began in the 20th century to see broader political value in evoking that ancient text. For if Eleanor Roosevelt could see Magna Carta as a universal document, that was partly because the whole world had already begun to do so. Let me cite 3 examples. On the 700th anniversary, at the height of the women's suffrage movement in 1915, leading British suffragette Helena Normanton wrote an essay entitled Magna Carta and Women. In it, she asked and answered 3 questions. Did women have any role in bringing about the Charter itself? Did it secure any rights to women? And is there any practical value in studying its particular clauses today? To each question, she answered yes. Key women were involved in the rebellion against King John, she said. The rights of the freemen in Clause 39, she suggested, were designed as rights of the freeholder, whether male or female. And most urgently, denying women the right to vote was expressly contrary to Magna Carta, she said, because of its guarantee that justice should be neither delayed nor denied. It's no doubt a mere coincidence, but women's suffrage in England took its most important step towards fruition a mere 3 years after the appearance of Normanton's essay. This particular movement has gone global. Promoters of women's rights have found inspiration in Magna Carta throughout the 100 years since Normanton's essay appeared. In 2009, for example, the Philippines government passed into law an elaborate statute which it officially called the Magna Carta for Women. A second global movement to invoke the Great Charter this past century has been anti-colonialism. Although the wave of sometimes violent rebellions against European empire that swept through the world after 1945 has often been looked upon as a flat-out rejection of Western values, more times than not, third world leaders, perhaps because they had what Jefferson once called a decent respect for the opinions of mankind, found it expedient to invoke Western values in explaining and promoting their agendas. Gandhi is a good example. Locked in a contest over the rights of Indian migrants in South Africa, Gandhi came to an agreement that in exchange for his leaving the country, the South African government would pass an Indian Relief Act. This act was a complicated compromise that included things as different as legalizing polygamy and repealing a migrants tax. But Gandhi saw in it nothing less than what he called the Magna Carta for our liberty in this land. He was quite explicit about what he meant by that careful choice of words. He meant that the Relief Act, too, had been the result of many years' struggle and grievance. He meant that for all its faults, the Act recognized a new right of consultation for the Indian people. And he meant that the Act, quote, confirms the theory of the British Constitution that there should be no legal racial inequality between different subjects of the Crown, unquote. So for Gandhi, Magna Carta seems like a kind of complex symbol of English ways with an emphasis on its role as a moral weapon of righteous conflict. My third and final example is perhaps the most thought-provoking, for me anyway. It's the case of Nelson Mandela. If we ask ourselves whether Magna Carta as a symbol ever actually shaped people's views or made a substantive difference at a decisive moment in recent world history, Mandela seems to me about as close as we get to an affirmative answer to that question. In looking at the long and self-revelatory speech Mandela gave at his trial for sabotage in 1964 in Rivonia, we see a man profoundly divided between two starkly conflicting sets of values. Having been charged earlier under the Suppression of Communism Act, Mandela now explained to the courtroom his exact relationship with communism. He said that he was, of course, sympathetic to that movement, which, after all, had been supportive of his African National Congress. Plus, he found the ideal of a classless society to be intuitively attractive. While not a communist himself, Mandela said that a socialist economy of some kind seemed an essential road to prosperity for his people. And he underscored that all of these views were widely shared among anti-colonial leaders. But against some of his communist comrades, he also said this, and I'll beg your patience as I read at length. He said the following: "The Magna Carta, the Petition of Rights, and the Bill of Rights are documents which are held in veneration by Democrats throughout the world. I regard the British Parliament as the most democratic institution in the world, and the independence and impartiality of its judiciary never fail to arouse my admiration. The American Congress, its separation of powers, as well as the independence of its judiciary, arouses in me similar sentiments," unquote. Like other anti-colonial leaders, Mandela struggled to make sense of the complicated inheritance that he could draw upon in giving shape to his movement. He sought to be, as he put it, absolutely impartial and objective, unquote, in reaching what he called a political formula appropriate to his situation. He felt that such a formula must include East and West, and that it must embrace elements of collectivism and individualism. If the regime that he set about to establish, when finally released from prison in 1991, contained more in the way of individual rights, protection of property, respect for the market, separation of powers, and an independent judiciary than any of his detractors had dared to hope, it seems to me not impossible that this was partly because Mandela resonated to the mystic chords of a long memory of individual liberty in the English-speaking world, beginning with Magna Carta. And this brings me back to Eleanor Roosevelt and the Universal Declaration. Before the war, it had generally been thought that treatment of individuals by governments was a matter of sovereignty, and that only the foreign and military policies of states were the legitimate concern of other states. The horrific destructiveness of government, wielded by the totalitarian regimes of the 1920s through the 1940s, and, by the way, those who resisted them, had changed the minds of many people. Now it was increasingly thought that a government that blatantly trampled over individual rights was distinctly more likely to pose a genuine threat to other nations as well. In that context, the idea of the Universal Declaration as a kind of international Magna Carta turns that musty old parchment into a kind of overarching symbol of the right of even the humblest individual to recognition and dignity. Although it is easy to become jaded by the sheer crazy quilt of disparate rhetorical uses made of Magna Carta, it seems to me a case can be made that the uses that have been most durable and successful are generally those that have been most effective at speaking to our shared, and if I dare say so, our growing sense of common humanity and individual dignity. One final oddity about this notion of individual dignity. The technological civilization on which we justly pride ourselves has become ever more individualized and customized over time. The clock tower gave way to the wristwatch, the telegraph gave way to the telephone, the railway gave way to the automobile, network TV gave way first to cable, then to the web. And yet, when most of us think of the phrase individual dignity, remembering that dignity means worth, we are not likely to think of our technology. We are likely to think instead of the capacity of persons to stand up in public, to sue and be sued, to expect fair and equal treatment, to be consulted about the laws and about those who make them. In this way, it may well be said that against remarkably long odds, a dusty parchment from a field in southern England has contributed as much to that mottled entity we sometimes call modern Western civilization as all the leading lights of Silicon Valley put together. Thank you for your attention.
Thank you, Mr. Clark. That was a very enlightening talk. Well, next up we have Professor Andrew Chodorow. Professor Chodorow is the Willard H. Pedrick Distinguished Research Scholar at the Sandra Day O'Connor College of Law. He specializes in tax law and has written on a variety of topics, including the connections between taxation and religious tithing, the taxation of virtual income earned online, and whether those who have died and come back as zombies should be considered dead for estate tax purposes. He is currently working on an article considering whether postgraduate teaching law firms can qualify for tax-exempt status. Please join me in welcoming Professor Andrew Chodorow.
Thank you very much. I'm going to take us in a slightly different direction from what we just covered. So as we've just heard, the Magna Carta is known for a variety of things, including trial by jury, including habeas corpus petitions. It has been described as, quote, the greatest constitutional document of all times, the foundation of the freedom of the individual against the arbitrary authority of the despot. It's often cited as the sort of foundation or containing many of the seeds found in our Constitution and the rights described therein. Now, if you paid attention to my title of my talk, it's the Magna Carta, a tax professor's perspective. And you may ask yourself, you know, what does a tax professor have to say about the Magna Carta? So, in the few moments that I have allotted to me, I want to convince you of the following claim. That modern Western democracy, starting with the Magna Carta and traced through to the current government we have today, is nothing more than a byproduct of tax disputes. So I intend to demonstrate this by working through the context and contents of the Magna Carta, by talking about the run-up to the Revolutionary War, the Declaration of Independence, the Articles of Confederation, and finally the Constitution itself. So let's start with the run-up to the Magna Carta action. So what happened, right? So we know that there was King John, and King John was the third of the Angevin kings. And he had a little bit of a problem. And the problem was that he owned land in France, and the King of France was not too happy about this. So he ended up engaging in a number of wars. Trying to keep his land, trying to get his land back after he lost it. And the problem is that wars are expensive. They're very expensive. And so how do you pay for wars? Well, certainly not with your own money. So what you do is you raise money from other people through taxes. So this, of course, tipped off the barons who were subject to these taxes. They revolt, and ultimately they meet in Runnymede in June of 1215 to sign the Magna Carta. So, what does the Magna Carta actually say? So the first thing it says in Article 1 is that the rights of the church are to be protected. All right, that makes sense. God goes first. But what's the second thing that they talk about in the Magna Carta? The very second clause relates to something called feudal relief. This is essentially the estate tax, right? If you held land from the king and died, and your heir wanted to collect his land, he had to pay a tax. And what this clause does is it says, all right, well, for earls it's 100 pounds, you know, if you're a baron it's 100 marks, etc. So it sets the limit of the estate tax in medieval England. But it goes beyond this. So the other tax clause that we find in the Magna Carta is about something called scutage or aid. So scutage is the amount you pay to avoid having to show up and actually fight the wars that your king has committed himself to. And so let's look at this language. It says, no scutage or aid may be levied in our kingdom without its general consent, unless it is for the ransom of our person, to make our eldest son a knight, and once to marry our eldest daughter. And for these purposes, only a reasonable aid may be levied. So again, we have a limitation on the ability to tax. But I really want to focus on this language here. Without its general consent, here is the core deal of the Magna Carta. It is, if you are going to tax us and take our money, then we get to have a say in government. In other words, we get to decide. So what does this develop into? Ultimately, that simple clause that was outlined in red develops into the modern day parliament, which gives Englishmen a say not only in taxes, but in all other laws that get passed throughout the land. So what I want to do next is fast forward a couple of centuries and talk about the run-up to the American Revolution. So once again, we have a war. This time it is the 7 Years' War or the French and Indian War, depending on what part of the world you live in. And it's a war that is fought between the British and the colonists on the one hand, the French, Indians on the other, and perhaps a few others. So what do we know about war? We already learned this in 1215, right? War is expensive. And the British spend a lot of money defending, among others, the colonists. So they say, well, we need to pay for that war. How are we going to do it? Well, that leads us to Charles Townshend. Charles Townshend was a British politician who ultimately became the Chancellor of the Exchequer. And one of his favorite things to do in life was to tax the colonists. So we start with the Stamp Act in 1665. The Stamp Act applied to activities that happened within the colonies. This is what we typically call a direct tax. It was extraordinarily unpopular in the colonies, and there was some real question about whether Parliament even had the power to legislate behavior within the colonies themselves, as opposed to, say, export or import taxes, which would have been sort of external to the colonies. That law lasted about a year, maybe even less than a year. It was repealed. The next year, in 1766, they passed the Declaratory Act, which basically says, yes, Parliament does have the power to impose taxes and control what goes on in the colonies. And the very next year, they passed the dreaded Townshend Acts. So what are the Townshend Acts? What the Townshend Acts do is that they impose duties on glass, on lead, oil, paint, papers, and most famously, on tea. Now, these were seen as indirect taxes because they were taxes on goods that were being imported into the colonies as opposed to behavior that happened within the colonies themselves. So these were extraordinarily unpopular as well, and they were repealed in 1770 except for the tax on tea. And you might think that the colonists would have been grateful, but you would be wrong. They were still pretty ticked off. And in fact, what ended up happening is we led to the Boston Tea Party, right? Where a bunch of colonists dress up as Indians, board the ship, and dump the tea into the Boston harbor so the British cannot collect the taxes. So what's the problem with the taxes? Well, part of it is that they're just taxes and we hate taxes. But the other part of it is that the taxes are imposed by Britain without any representation by the colonists in Parliament. In other words, a violation of the core idea that we saw in the Magna Carta itself. So let's go forward. we have our Tea Party, and we say, you know what, we're going to declare independence. And what are we going to say in our Declaration of Independence? Well, I'm taking this a little out of order, so pardon me for this. But we hold certain truths to be self-evident, that all men are created equal, that they're endowed by their Creator with certain inalienable rights, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. Right? So this is that idea, again, that we saw in the Magna Carta. It's gone from, if you're going to take my money, I get a say in government, which is, if you're going to rule over me, I get to say something about it. So what was the purpose of the Declaration of Independence? So when in the course of human events it becomes necessary for one people to dissolve the political bounds which have connected them with another, let's skip down to the bottom here. A decent respect to the opinions of mankind requires that they should declare the causes which impel them to separation. In other words, it's only good manners to tell you why we are, in fact, declaring our independence. And if you scroll down the document, you will see, for imposing taxes on us without our consent, right? This comes straight out of the Magna Carta. Now, I'm not going to claim that this is the only complaint that the colonists had, but it was certainly one of the central complaints, as we can see from the Boston Tea Party and a lot of the writings at the time. So after you declare your independence, it's almost a point of no return. So what do we get? We get the shot heard around the world. We get, eventually, Washington crossing the Delaware in 1783. We get victory. And by now in the talk, I'm hoping you all know what the next slide is. What do we get? Debt! Why? Because war is expensive. War is very expensive. And the problem for the colonies, the now independent colonies, is that the federal government was unable to raise any money, any taxes, so they had to borrow. So they borrowed from France, they borrowed from Holland, they borrowed from Spain, they borrowed from a number of individuals. And they had a problem. How do we pay back this debt? Now, the answer is, well, why not just not pay it back? But that wasn't an option, because having just won their independence, they were scared to death that England was coming back next year, or some other power would swoop in and try to take over what they had fought so hard to liberate. And to be able to defend themselves, they were going to need credit. And if you don't pay back your debts, you get no credit. So what students of American history will know that the Constitution is actually U.S. government version 2.0. So, right, what's version 1.0? Version 1.0 is something called the Articles of Confederation. Now, these articles were created, drafted in 1777, right after the Declaration of Independence, and they were adopted in, I believe, 1781, which is before the war ended. So this was the government in place during the Revolutionary War. Now, the vision of this government was that it be extraordinarily weak and very limited. Each colony sent a delegation of 2 to 7. Each colony got 1 vote. Even if they had 7 people, they only got 1 vote. All votes had to be unanimous, or nothing happened. So this is a government, by the way, that has no president, no courts, no agencies, nothing. And more important, or perhaps most important for purposes of my talk, it doesn't have the power to tax. So how is it supposed to get its money? It says all charges of war and other expenses shall be incurred, defense and allowed by the United States shall be defrayed out of a common treasury, okay, that's good, which shall be supplied by the several states in proportion to the value of all land within the state. In other words, the federal government has 0 ability to tax. And to make it even clearer, Article 8 goes on to say the taxes for paying that proportion, the state's proportion, shall be laid and levied by the authority and direction of the legislatures of the several states within the time agreed upon by the United States and Congress assembled. So basically, federal government, extraordinarily weak, no power to tax. So what they had to rely on were these things called requisitions, where they asked the states for money. Now, there were actually efforts in 1781 and 1783 to give the national government taxing power, but they were defeated. Why? Because you had a unanimity requirement, and at least 1 colony or state objected. So the final requisition was in 1786. Congress requested $3.8 million. Anybody have any idea of how much they actually were collected? No, $663. Right, so the system was broken, and there was no way to repay the taxes. So the question is, what do you do next? They decided, well, let's get a convention together and try to fix the Articles of Confederation. So they gather in Philadelphia, they sit down, they look at each other and say, this thing ain't going to be fixed. Let's scrap it and start all over. So this is how we end up with our Constitutional Convention. It wasn't actually designed to create the Constitution. It was designed to fix the Articles. But they gave up because it was so deeply flawed. So what we ended up with at the end of it is what we all know, version 2.0, the Constitution. So one of the key fixes, one of the key problems they had, the reason they had to scrap the Articles, was because the federal government couldn't raise any money. So what did they do? They created Article 1, Section 8. The Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense. So we have given Congress, or rather the government, the power to tax. And more important, this power to tax applies to taxes on people as opposed to taxes on the states. So the old system was you send out to the states and say, please give us money. Now we're going to impose the taxes directly on the people. So this has, this was hotly contested. It almost tanked the entire enterprise. But it raises the conundrum that we saw earlier with the Magna Carta, which is that if you're going to tax people, you're going to have to get the consent of the taxed. So this has significant implications for both the ratification process and also for the very form of the government that you have in the first place. So let's start with ratification. If you paid attention to your history, you'll note that the states actually didn't ratify the Constitution. The ratification conventions were held in states, but it wasn't the states acting as states that did it. And in fact, if you want to know who ratified the Constitution, you just look at it again. It says, we the people. We ratified the Constitution. We gave the federal government the power to tax, not the states. So the next question is, well, it's one thing to give them the power to tax, but what about consent for the specific taxes that the government might actually give? Right? We're going to need to have some consent for that too. So if you look at Article 1, Section 2, you'll discover that we now have something called a House of Representatives composed by members chosen every second year by whom? By the people of the several states, right? So this is quite different from the Articles of Confederation. And how are those representatives going to be allocated? They're going to be allocated based on representatives and direct taxes shall be apportioned among the several states, which may be included, according to the respective numbers. So we're going to have proportional representation in this new thing called the House to account for the need to consent to the taxes that are now going to be imposed. Now, they also created a Senate, and so what we actually ended up with is a hybrid. So you've got the Senate who would appoint senators. It's no longer the law. It might be again if certain conservatives get their way. But you had the states coming in and appointing the Senate, but you had the people electing the House of Representatives. So what other things does this sort of power to tax do to the way in which we create the government? So one is we now have two houses of our legislature, whereas before we just had an organization of states. But we have other things too. So for instance, we have something called the origination clause. All bills for raising revenue shall originate in the House of Representatives. Right? This is the only kind of bill where the Constitution says where it has to start. Right? Why do we have that? Because the people need to consent to taxation. And if you want to do that, the best way to do it is have the people actually propose the taxation in the first place in the form of a bill out of the people's representatives. So what else is there in the Constitution? Well, if we go back to the power to tax, I had cut it off before, but you'll see at the very end here it says, but all duties, imposts, and excises shall be uniform throughout the United States. So this is referred to as the uniformity clause, and it's a limit on the ability to tax. So how does that work? What's that about? Well, think about it. If you are, say, New England or the New England states, and you want to have an import tax, right? How about having an import tax of, say, 4% in all New England states, but for Virginia we'll make it 12%, right? That's a problem. So even when you have consent, right, when you have majority rule, which we've just moved to, not unanimity, we have to protect the minority, because on some level the minority cannot be said to have consented, especially when they are treated disparately. So the uniformity clause here, I think, can be seen as a limitation on Congress to ensure that consent is properly obtained and that people are protected in a system where consent applies. But uniformity won't do it all. Why? Well, let's imagine that you're sitting there saying, okay, all taxes have to be uniform, but why don't we have a tax on tobacco? Right? If you're sitting in New England, that tax looks pretty good because you're not going to pay any of it. Right? Or if you're down in the South, they get together and say, let's put a tax on Boston baked beans. Because they don't eat a lot of Boston baked beans down in the South, but they eat a lot up north. And so we have this problem of, again, the majority imposing its will on the minority. So we have another provision, and we've seen it before, but I'll show it to you again, that representatives and here's the word, direct taxes shall be apportioned among the states, blah, 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 according to their respective numbers. So basically, if you have 10% of the population, you're going to have to pay 10% of that tax. And again, what this does is it protects people against the majority ganging up on a minority. So states with a lot of people and have representative power and can control the government can't impose taxes on other people. We need consent. So this is so important, by the way, they put it in twice. So no capitation, which is a head tax, or other direct tax, shall be laid unless in proportion to the census, etc. So here are our twin protections, again, to make sure that although we have consent, we don't let our democratic principles run away with us and allow majorities to oppose or impose on minorities. So, in conclusion, the ideal of democracy is wonderful, right? And we read lots of wonderful prose and philosophical tracts about the nature of governing and how they have to participate. But in reality, what I want to argue today is that where it comes from, this right to self-governance, doesn't come from some high platonic ideal, but rather it comes from the very practical fact that governments need money. And in order to get their money, they need to give something up. And that, as I started with, modern Western democracy, starting with the Magna Carta and coming through to the very form of our own government today, is nothing more than a byproduct of tax disputes. So, thank you.
Thank you, Professor Chodorow. That was a very interesting perspective. Well, next up we have Myles Lynk. And Myles Lynk is the Peter Kiewit Foundation Professor of Law in the Legal Profession at the Sandra Day O'Connor College of Law here at ASU, where he teaches legal ethics, corporate law, federal administrative law, law in the regulatory state, and law in literature. Myles chairs the American Bar Association's National Standing Committee on Ethics and Professional Responsibility, and is a recipient of the ABA's Spirit of Excellence Award. Myles is a member of the Selden Society of Early English Legal History, and in 2014 was a visiting fellow at Magdalen College, Cambridge, and a visitor in the Faculty of Law at the University of Cambridge. His most recent article compares regulatory changes affecting the legal profession in England and Wales with the regulation of lawyers in the United States. Please welcome me in welcoming Myles Lynk.
Thank you very much. Well, now that Adam has stood constitutional law and Magna Carta historiography on its head, and with to great effect, I will sort of bring us back to a more traditional mode of analyzing Magna Carta and its impact on the United States. But one of the things that's very important, which I will refer to, is this question of who gets the power to tax and the enumerated powers in the Constitution and their effect in limiting the exercise of authority by the executive. I think if there's any sort of two things that Americans know about the Magna Carta, the Great Charter, one is that it was signed by King John of England, King Richard's evil brother, who was an enemy of Robin Hood, and two, that it did set forth limits on the prerogative power of the king. In Magna Carta, the king agreed for himself and his heirs that there were lawful limits to what he or his ministers and courts could do in his name. Therefore, as a consequence, these limits defined the extent of the rights the nobles and freed men of the kingdom had, which he was bound to respect. In fact, an argument can be made and has been made that by limiting the concept of the divine right of kings, Magna Carta established a basis for the rule of law as applied to executive authority. What all Americans may not realize about Magna Carta is that as a written statement of limits on executive authority and the rights of the people vis-a-vis their government, it has in some ways exercised a stronger and more profound influence on the United States than it has on Great Britain. In 1957, the American Bar Association erected a monument to Magna Carta at the field in Runnymede where it was signed. For many years, this was the only monument to Magna Carta at Runnymede. In 2015, during the 800th anniversary celebration of Magna Carta, the ABA returned to Runnymede to dedicate a refurbished monument at a ceremony attended by Queen Elizabeth II, Prime Minister Cameron, and other British and American officials. As Americans, we revere Magna Carta, perhaps because, as I said, we have a written constitution while the British do not. So the idea of a written enumeration of the rights of the people vis-a-vis their rulers is more congenial to us. Our founding fathers looked to the Magna Carta and other written charters for guidance and inspiration. Now, what gave rise to Magna Carta? The previous speakers have both addressed this. I will briefly. It was originally created because of disagreements between not just King John and the English barons, but also Pope Innocent III and King John about the rights of the king. Magna Carta required the king to renounce certain rights, respect certain legal procedures, and accept, quote, the will of the king could be bound by law, close quote. Among other things, the charter regularized relations between barons and tenants to avoid royal interference and abuses. It prevented the arbitrary taking of land or property from subjects by the state. It assured freedom to the church from royal authority. It regulated the courts, bailiffs, and other judicial officers, and it put limits on the king's ability to affect or limit the movements of foreign merchants. Perhaps the most famous provision of the charter were those preventing a man from being convicted without due process of law. Clause 39, Clause 40, and Clause 52. This meant that a man could not be imprisoned, exiled, made an outlaw, or have his lands confiscated without going through proper established legal procedures. For example, a fair trial, either by battle or by jury. The charter's immediate result was to familiarize people with the idea that by means of a written document it was possible to make notable changes in the law. This lesson was not lost when, 500 years later, the Founding Fathers came to draft our own Constitution. For King John, the most significant clause in Magna Carta was probably Clause 60, Clause 61, known as the Security Clause. This is the longest clause in the document. It established a committee of 25 barons who could at any time meet and overrule the will of the king through force, by seizing his castles and possessions if needed. This was based on a medieval legal practice known as restraint, but this was the first time this practice had been applied to a monarch. In addition, the king was to take an oath of loyalty to the committee. One of the interesting questions historians ask is, did King John ever really intend to honor Magna Carta? After all, it was sealed under extortion by force, and Clause 61 essentially eliminated his power as a monarch, rather than simply limited, making the king, for certain purposes, a king in name only. And so it's no surprise that King John renounced it as soon as the barons left London, plunging England into a civil war called the First Barons' War. What's interesting is that although Magna Carta guaranteed the church's freedom from interference by the king, Pope Innocent III also annulled what he called the shameful and demeaning agreement forced upon the king by violence and fear. He rejected any call for rights, saying it impaired King John's dignity. But in reality, the Pope saw it as an affront to the church's authority over kings and temporal leaders, because it was enforced on the king by other temporal leaders, meaning the barons. And so he released John from his oath to obey it. Nonetheless, many of the clauses in Magna Carta were renewed throughout the Middle Ages and further during the Tudor and Stuart periods in the 17th and 18th centuries. By the early 19th century, however, most clauses have been repealed under English law. In fact, an argument can be made that the document commonly known as Magna Carta today is not actually the 1215 Charter, but a later charter of 1225, and that is usually shown as the form of the charter of 1297 when it was confirmed by Edward I. At the time of the 1215 charter, many of the provisions were not meant to make long-term changes, but simply to right immediate wrongs of the barons. And therefore the charter was reissued 3 times in the reign of Henry III in 1216, 1217, and 1225 in order to provide for an updated version. After this, each individual king for the next 200 years until Henry V in 1416 personally confirmed the 1215 charter as their own charter. Nonetheless, rights established by the Magna Carta have subsequently become fundamental principles of international human rights, and it can be argued that democratic societies around the world have developed as a long-term consequence of this charter. Over the centuries, Magna Carta has become a symbol of the rule of law. As one commentator later explained, the charter established the basic principle that the rule of law ensures personal liberty. First, the executive power must proceed by recognizing legal process never unlawfully, and second, no one is above the law, however high his or her status. Thus, although Magna Carta does not specifically state that the king is subject to the rule of law, it does provide in Chapter 61 of the original version that the barons have the authority to enforce the document. This meant that the king could no longer ignore or easily violate established laws, traditions, or customs, or arbitrarily infringe upon the rights of his subjects. Magna Carta exercised a strong influence on both the United States Constitution and on the constitutions of the various states. But this influence was largely shaped by what 18th century Americans believed Magna Carta to mean. And the meaning ascribed to it was first, that the executive should not have unlimited power, and second, that the citizens of the state must be able to assert their rights against the government. That is, by defining their rights, they establish and preserve their rights. This nicely captured the distrust of government in early colonial America, not just of the Crown of England, but in America at the time. As a result, for example, as you've heard, the Articles of Confederation government, which was the first national government established by the Founding Fathers, was a very weak government, a very decentralized form of government. Most of the state constitutions adopted at that time among the original states included declarations of rights intended to guarantee individual citizens a list of protections and immunities from the state government. Thus, for example, in our own Bill of Rights, the language in the Fifth Amendment to the U.S. Constitution says, "Nor shall any person be deprived of life or liberty without due process of law," and that is actually an echo of Clause 39 in Magna Carta, which reads, "No free man shall be taken or imprisoned or diseased or outlawed or exiled or in any way ruined, nor will we go and sin against him except by the lawful judgment of his peers or by the law of the land." Similarly, Clause 40 of Magna Carta reads, "To no one will we sell, to no one will we deny or delay right or justice." Again, a guarantee of due process. And in Clause 52, "If anyone has been diseased or deprived by us without lawful judgment of his peers, of lands, castles, liberties, or his rights, we will restore them to him at once. And if any disagreement arises on this, then let it be settled by the judgment of the 25 barons referred to below in the security clause." Again, a guarantee protecting the citizens, protecting barons and freedmen against the arbitrary exercise of power by the king. But before we even get to the Bill of Rights, Article 2 of the U.S. Constitution contains many limitations on executive authority designed to prevent the emergence of the king, despotic or otherwise. First, and most obvious, the president must be elected. And the president must be elected every 4 years. It was not until the 22nd Amendment in 1948 that a president was limited to being elected to 2 terms of office only, but in fact, the precedent set by George Washington was a precedent followed by every president until Franklin Roosevelt. The president, vice president, and all civil officers can be removed from office or impeached and convicted of treason, bribery, or other high crimes or misdemeanors. The president, under Article 2, is commander-in-chief of the armed forces, but only Congress, under Article 1 of the Constitution, can declare war. Although the War Powers Resolution muddies this water a bit, and in recent years presidents have committed U.S. forces to many hostilities short of a formal declaration of war. The president can make treaties on behalf of the United States, but such treaties must then be presented to and ratified by 2/3 of the Senate. The president has the authority to nominate cabinet officers, ambassadors, federal judges, and Supreme Court justices, but such appointments must be ratified by, with the advice and consent of, the Senate. And the president is required by the Constitution to, quote, from time to time, report to the Congress on the state of the nation, the state of the Union. To the founding fathers for whom the legacy and legend of Magna Carta was so instructive, these limitations on the executive under the Constitution seemed both necessary and advisable. Adam referred to Section 1, Article 8 of Section 8, Article 1 of the Constitution, and that's Article 1, Section 8 actually enumerates many specific powers that are given by the Constitution to the legislature, and by giving those powers to the legislature, they in effect mean that the executive does not exercise them at all or unilaterally. For example, the power to levy taxes, the power to raise funds in order for the government to operate is a power that the Congress must authorize before the Treasury Department, if you will, can collect. Also, the power in the Constitution under Article 3 of the courts, the federal judiciary. Article 3 originally, and Article 3 only refers to the Supreme Court of the United States. Subsequent legislation created other courts in the federal judiciary. There's nowhere in Article 3 do we see a reference to the authority of the Supreme Court to engage in judicial review of legislation passed by the Congress and signed into law by the President. But in fact, in Federalist Number 76, Madison already conceptualized the view that a Supreme Court would have that authority of judicial review. And as you know, in the famous case of Marbury versus Madison, Chief Justice Marshall of the Supreme Court adopted that theory of judicial review to strike down a statute, and that set a precedent which continues to this day. Interestingly, however, despite the widespread adoption of declarations of rights in state constitutions, many of the framers, including George Washington, opposed adding a Bill of Rights to the United States Constitution. Now, in part, I want to read a little bit from the Federalist 84 and Alexander Hamilton's explanation of why a Bill of Rights was not necessary. And then I want to read the rebuttal by one of the anti-federalists to Hamilton. But there was also a political dimension to this. Getting the Constitution ratified was so difficult that the framers did not want to have to go back to Philadelphia and add language and thereby perhaps lose some votes for the Constitution. That was one initial objection. And the other objection was, well, if we get the Constitution ratified despite objections that there are no Bill of Rights, if we then have to go back and amend it, won't that suggest a weakness in the government that we don't want to suggest so soon after the Constitution has initially been ratified? But those are political concerns, and in the Federalist number 84, Hamilton articulated a more principled objection to a Bill of Rights in defense of the Constitution as it then stood. And with your permission, I'd like to read his statement. It has been several times truly remarked that bills of rights are, in their origin, stipulations between kings and their subjects, abridgments of prerogatives in favor of privilege, reservations of rights not surrendered to the prince. Such was Magna Carta, obtained by the barons sword in hand from King John. Such were the subsequent confirmations of that charter by succeeding princesses. Such was the petition of right assented to by Charles I in the beginning of his reign. Such also was the Declaration of Right presented by the Lords and Commons to the Prince of Orange in 1688, and afterwards thrown into the form of an Act of Parliament called the Bill of Rights. It is evident, therefore, that according to their primitive signification, they have no application to constitutions professedly founded upon the powers of the people, and executed by their immediate representatives and servants. Here, in strictness, the people surrender nothing, and as they retain everything, they have no need of particular reservations. We, the people of the United States, to secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Here is a better recognition of popular rights than volumes of these aphorisms, which make the principal figure in several of our state bills of rights, and which would sound much better in a treatise of ethics than in a constitution of government. And then Hamilton continues, I go further and affirm that bills of rights, in the sense and to the extent to which they are contended for, are not only unnecessary in the proposed Constitution, but would even be dangerous. They would contain various exceptions to powers not granted, and on this very account would afford a culpable pretext to claim more than was granted. For why declare that things shall not be done when there is no power to do them? Why, for instance, should it be said that the liberty of the press shall not be restrained when no power is given by which restrictions may be imposed? Now that is I think you would agree, a very well-articulated argument against adding a Bill of Rights to the Constitution. Whether you agree with the argument or not, it's nonetheless a very well-articulated presentation. This assertion was answered by an anonymous anti-federalist who went by the name of Brutus. And as some of you know who've read the materials from that time, many of the Federalists and anti-Federalists, the Federalists published, did not use their names when they published their documents, and the anti-Federalists also used fictitious pseudonyms from ancient Roman history. In a tract, Brutus wrote, "Those who have governed have been found in all ages ever active to enlarge their powers and abridge the public liberty. This has induced the people in all countries where any sense of freedom remained to fix barriers against the encroachments of their rulers. The country from which we have derived our origin is an eminent example of this. Their Magna Carta and Bill of Rights have long been the boast, as well as the security of that nation. I need say no more. I presume to an American that this principle is a fundamental one in all the constitutions of our own states. There is not one of them but what is either founded on a Declaration or Bill of Rights or has certain express reservations of rights interwoven in the body of them. It has been said in answer to this objection that such declarations of rights, however requisite they might be in the Constitution of the states, are not necessary in the general Constitution because, in the former case, everything which is not reserved is given, but in the latter, the reverse of the proposition prevails, and everything which is not given is reserved to the people. It requires but little attention to discover that this mode of reasoning is rather specious than solid. The powers, rights, and authorities granted to the general government by this Constitution are as complete with respect to every object to which they extend as that of any state government. It reaches to everything which concerns human happiness. Life, liberty, and property are under its control. There is the same reason, therefore, that the exercise of power in this case should be restrained within proper limits as in that of the state governments. I think you'd agree that's a very powerful response by someone who is still anonymous to us today to Alexander Hamilton's statement. Eventually, in fact, the anti-federalist position prevailed, and in response to the suspicions and concerns of the anti-federalists, who had strongly opposed the ratification of the Constitution and now lobbied vigorously for the adoption of a Bill of Rights, amendments to the Constitution guaranteeing a number of personal freedoms, limiting the government's power in judicial and other proceedings, and reserving some powers to the states and the public, were proposed by James Madison. And in 1791, they were adopted. Originally, the amendments applied only to the federal government. However, most were subsequently applied to the governments of each state by way of the 14th Amendment to the Constitution. As we know, the Bill of Rights enumerates freedoms not explicitly indicated in the main body of the Constitution. These include freedom of religion and prohibiting the government from creating an established church, freedom of speech, freedom of the press, freedom of assembly, the right to keep and bear arms, freedom from unreasonable searches and seizures, security and personal property, freedom from warrants issued without probable cause, indictment by a grand jury for any capital or infamous crime, guarantee of a speedy public trial with an impartial jury, and prohibition of double jeopardy. In addition, the Bill of Rights reserves to the people any right not specifically mentioned in the Constitution and reserves all powers not specifically granted to the federal government to the people or the states. Magna Carta was clearly a great influence in the framing of these Bill of Rights and in the presentation of them to the Congress and then to the states for ratification. And in fact, because Magna Carta existed, it provided a template that the adopters and the drafters could follow, and which the anti-federalists, as we saw in the excerpt from Brutus, could rely upon in their demand that a Bill of Rights was necessary to protect the citizens against encroachment by the government. And of course, the encroachment they most feared was encroachment by the executive branch. In fact, as the evolution of the law in England has evolved, the legislature, the parliament, is all powerful today. Whereas in the United States, we have the separation of powers between our three branches of government, upon which the executive, although one branch of government, a powerful branch of government, certainly is limited and constrained within a body of laws represented by the Constitution, the idea of which emanates from the Magna Carta and carries forward the Magna Carta's principle that the executive cannot operate in an arbitrary manner, free of legal restraints by the people. Thank you.